Здравейте отново, уважаеми колеги, гости. Започваме следобедната сесия в нашата конференция. Надяваме се, че почивката за обяд е била приятна и ползотворна. За следващата сесия, презентацията, която предстои да чуем, ще бъде в онлайн формат през нашата виртуална конферентна зала. И имам удоволствието да представя нашия следващ говорител. И поради тази причина, тъй като за да можем да комуникираме и с хората в Zoom, ще мина на английски език. So our next speaker for this afternoon is Dr. Adriano Martufi, who is an assistant professor with the University of Leiden in the Netherlands. And he specializes in criminal law. And his main area of expertise includes the rights of prisoners in a European and comparative perspective, as well as the transformation of probation and community sanctions in Europe. And for today's session, he'll be essentially continuing the conversations that we had from this morning and the discussions on fundamental rights. So without further ado, Adriano, please, you have the floor. Thank you.
Thank you very much, Sophia. It's a big pleasure to join this event, although unfortunately by remote, and I have to excuse myself, of course, and apologize for the attendees who are there with you for not being able to attend in Sofia this very interesting event, which culminates at the end of a very interesting project from which I gather very interesting information via the website, and I think that the works of your conference today will provide further insights from practitioners and academics that deal with European criminal law. So after these necessary and unfortunately heartfelt apologies for my absence, I would like to share my screen to provide some more detailed information about my presentation, which are contained in my slides. I hope you can see, that you all can see the screen I'm sharing at the moment. If not, feel free to interrupt at any time. So the title of the presentation was suggested by me in light of the topics that were proposed for these conferences, including the role of fundamental rights in judicial cooperation. So I picked up on these suggestions by the organizers and proposed this title, which in my intention should illustrate the dual dimension or that fundamental rights of the individual are playing and have been playing in the context of EU judicial cooperation in criminal matters. And the questions I'm trying to ask with this presentation, and which might lead us perhaps later to a discussion on some of the points I raise in my talk, is whether fundamental rights are effectively a brake for the approximation of laws and criminal justice practices across the different member states of the EU. So basically, if fundamental rights are a factor that slows down effectively this process of approximation, or if, on the contrary, they might be regarded as one of the drivers of this process of approximation that is leading jurisdictions and criminal justice systems across the different member states more and more closer together. So that's the main questions I would like to address. I'm not sure I would have a final answer for this question. I can tell you already. So that it's very much an open question, but which might hopefully neatly takes us into a discussion later. I would begin by framing the problem of fundamental rights in EU criminal justice by looking at the very troubled relationship that exists between the principle of mutual recognition that that you're all familiar with and that you most likely heard talking about in the previous panels today, defined as the cornerstone of EU judicial cooperation in criminal matters since the Tampere program adopted by the Council in 1999. And on the other side of the spectrum, trying to figure out how the notion of mutual recognition and this principle, and especially its operational implications, have an impact on the role of individual and the role of individuals, more generally, I would say, in interstate judicial cooperation proceedings. The principle of mutual recognition has been defined as the motor of EU integration in criminal matters. The reason for this are manifold. There are many reasons to explain the relevance of mutual recognition in the process of EU integration of criminal law. One of them being the convenient function that mutual recognition can play in connecting, in making different jurisdictions and criminal justice systems talk to each other, effectively connecting them, allowing for cooperation, transfer of sentences, transfer of requested person, but also transfer of evidence, of course, in a way that does not require or imply any form of harmonization. So it is a matter of bringing about integration without impinging too heavily on national discretion, on national sovereignty, and on the power of member states to maintain a certain degree of control on their criminal policy. So that is why we can look effectively at mutual recognition as the motor, the driver, one of the drivers of the EU integration when it comes to criminal law and criminal justice. But there's another thing that we probably need to bear in mind to understand the centrality of mutual recognition, which since the Treaty of Lisbon has been explicitly mentioned as one of the governing principles of EU criminal law in the Treaty on the Functioning of the European Union. So it now has a fully fledged legal status that it didn't have prior to these treaty reform. And this aspect that we need to bear in mind is the compensatory logic that sits behind the adoption of the principle of mutual recognition. And what do I mean by that is the idea of allowing for a greater and more effective cooperation between judicial authorities, law enforcement officials, including, of course, the police, across the different member states, in a time where, especially in the 90s, after the incorporation of the so-called Schengen acquis, the acquis of the Treaty of Schengen, and the removal of border controls across the different member states, there was effectively an increased mobility of citizens, different member states, within the Schengen area, which was by many associated with a somehow presumed, sometimes more documented, but still central in the policy debate. But like I said, a rise in the transborder or transnational forms of crimes. And so in that respect, the use of mutual recognition as a very swift and effective means to bring together, connect criminal justice systems and their authorities in different member states has been seen as a way to compensate to the increased mobility of citizens within Schengen, to the lower level of border controls and police controls at the borders, in a way that would make judicial cooperation and therefore legal aid and extradition processes more effective. The first incorporation, the first measure that has effectively fleshed out the principle of mutual recognition in legal terms, so in a way that is more operational because it's part of a legal instrument adopted by the EU, which is binding for the member states, and deals with a very important area of criminal justice cooperation, is the framework decision on the European arrest warrant that was already mentioned in the discussion this morning, if I'm not mistaken, and will be dealt also by other speakers later. And the inclusion of the principle of mutual recognition in the framework decision on the European arrest warrant is to some extent emblematic of a change in the lawmaking process within the European Union law with regard to criminal justice. And the most important aspect that we need to bear in mind in order to understand the practical impact of mutual recognition in criminal justice and with regard to the European arrest warrant is the fact that mutual recognition essentially implies a duty to recognize, as the word suggests, recognition implies a duty to recognize, but also to enforce, mostly, but not exclusively, foreign judicial decisions adopted by judicial authorities in other member states, and therefore clearly distinguishes between the role of an issuing authority that adopts a request, in this case, a European arrest warrant, and on the one side, and on the other side, an executing authority that is called upon to enforce such warrant, or more specifically, I would say, the judicial decisions underpinning such warrant, for instance, a national arrest warrant that is presupposed whenever a European arrest warrant is issued. As I was saying, to enforce such warrant within their own legal systems without many formalities, unlike the prior and traditional practice of extradition proceedings, without the involvement of political authorities, such as the Ministries of Justice, but especially with a high degree of, beg your pardon, with a high degree of automaticity, namely with the effect of making the enforcement and the recognition of a foreign judicial decision almost automatic. The automaticity that is one of the most important corollaries of mutual recognition is taking the shape of different provisions that we can find in the framework decision on the European arrest warrant and in other subsequent framework decisions that implement the principle of mutual recognition. And the most common and the most salient aspect of this form of automaticity are the limited time frame within which a foreign judicial decision has to be executed in the executing member state, and the removal of the very common requirement in extradition practice of dual criminality for a number of areas of criminality, of crime, in which it is assumed that stronger and more effective cooperation is needed, in particular in areas of criminality which are transnational in nature, like drug trafficking and terrorism. And also, what's more important perhaps for the purposes of our discussion today, automaticity implies a limited, very limited and exhaustive list of grounds for refusals. So reasons that may justify the executing authority to say no to the enforcement and the recognition of a foreign judicial decision. The whole idea of automaticity, which, as I will say in a minute, creates tension with the role that fundamental rights can play, has to do with the fact that in the first phase, at least, of EU criminal law and judicial cooperation in criminal matters since the early 2000s, the law enforcement needs, the needs of putting up a very effective and rapid response to some forms of criminality generating an important social demand of protection and a higher risk for collective security, such as terrorism, as I said, justifies the fact that the need of prosecution, especially, but also those underpinning the enforcement of punishment across different member states, were put in the forefront. So they are very much right front and center. If you look at the framework decision on the EAW and other contemporary framework decisions, these are the most clearly stated goals, I would say, of those legal instruments. And the reason why this was believed to be possible, so the reason why it was believed to assume that law enforcement needs and concerns had to be emphasized so much, has to do with an idea that we will discuss more in detail today, which is a sort of presumption of mutual trust, which is, as you can imagine, is very clearly and tightly connected with the notion of mutual recognition. A mutual trust that member states cooperating with each other within the framework of the European Union would almost necessarily comply with fundamental rights across the board, and therefore mutual trust and trust in the respect of fundamental rights can essentially be presumed and doesn't have to be verified on a case-by-case basis. This is a very contentious and problematic statement, but we find it very clearly expressed in what could be defined as the first stage of the development of EU criminal law, developing essentially after the adoption of the Treaty of Amsterdam and since the end of the 90s and all along the 2000s, after the Tampere program that I mentioned, other policy documents were adopted, including a detailed program of measures that the Council adopted in 2001, stating the legal instruments that needed to be adopted on the basis of the principle of mutual recognition. And subsequently, this idea that mutual trust in the respect of fundamental rights is somehow implicit because all the member states that belong to the European Union, that are members to the European Union, subscribe or should subscribe to the values, including rule of law and democracy and the protection of fundamental rights that are stated under Article 2 of the current Treaty on the European Union. And on the basis of this assumption, we see subsequently in the following years, after the adoption of Framework Decision 9, of Framework Decision on the European Arrest Warrant in 2002, we have a series of court cases decided by the European Court of Justice. And these rulings essentially seem to embrace an idea of the balance that has to exist between mutual recognition, the law enforcement concerns that justify mutual recognition, and the role of individuals in a way that is clearly balanced, that is tipping the balance, if you like, in favor of the needs of the prosecution, of the needs of a more effective cooperation and law enforcement across different jurisdictions. An emblematic, I would say, example of this type of interpretation that we notice in the first period of the jurisprudence of the European Court of Justice on matters of judicial cooperation is the case of Melloni. And in the case of Melloni, which concerned a European arrest warrant issued by Italy to Spain, where Spain essentially contested the higher level of fundamental rights protection with regard to the right to be present at trial and the limitation and restrictions to trials in absentia. The court claimed essentially that a higher standard of fundamental rights in the issuing state, I beg your pardon, in the executing state, so in this case, Spain, should not and could not undermine the uniformity of in the application of EU law, and more specifically, should not impinge on the goals, the aims, and the effectiveness of framework decision on the European arrest warrant. Namely, assuming that those needs and those goals that risked being affected negatively by a higher standard of fundamental rights in the case at hand were essentially law enforcement concerns and law enforcement objectives, including, in the case of Melloni, the possibility of effectively enforcing a punishment that was handed down and confirmed in across 3 different degrees of judgments in Italy, in a way that would not sort of make it impossible to enforce punishment and therefore create a sense of impunity. So the interpretation that the court gave to the framework decision on the European arrest warrant in these and other cases is emblematic of the balance between mutual recognition and rights of individuals, tipping totally in favor of the former. In addition to that, in a very contentious opinion, the opinion 213 issued by the Court of Justice in relation to the possible or proposed accession of the EU to the European Convention on Human Rights, the court, among other things, after rejecting the compatibility with the treaties of the proposed accession, made a few interesting points on the notion of mutual trust, naming it a principle, stating that mutual trust in the respect of fundamental rights within judicial cooperation in criminal matters should be somehow presumed, and going as far as to say that member states, in fact, when cooperating, have a duty to trust each other. And I would like to read a passage, a paragraph from this opinion, where the court essentially says that the principle of mutual trust requires, in the area of freedom, security, and justice, that each state, save in exceptional circumstances, has to consider, and so there is a duty in this respect, to consider that other member states are effectively complying not just with EU law, but particularly with the fundamental rights recognized by EU law. And that brings us to Article 6 of the Treaty on the European Union and the respect of fundamental rights that are enshrined not just by EU law itself, but also by other sources, including the European Court, the European Convention on Human Rights is its case law, other international treaties that member states are signatories of, and those fundamental rights resulting from the national constitutional traditions of the member states. So these duty to trust should only be rebutted, should only be overcome or derogated, if you prefer, in exceptional circumstances. But the court did not make clear what the notion of exceptional circumstances should mean, and it remained pretty difficult to establish to what extent this duty to trust each other could be derogated. In its way, this idea that derogations to mutual trust are just an exception was also confirmed by the Commission, the European Commission, which for a long time, during the 2000s especially, adopted reports on the implementation of the framework decision on the European arrest warrant, which was still at the time the most commonly used framework decision among the different member states, saying that effectively member states can rely on this presumption that mutual trust, that fundamental rights are respected, basically because they're all state parties to the European Convention on Human Rights. And therefore, and that was the argument put forward by the Commission in its reports in the 2000s, affected individuals, so individuals affected by a request of mutual of transfer or of surrender in the basis of the European arrest warrant, could eventually, after the exhaustion of domestic remedies, challenge a national decision before the European Court of Human Rights, and that would be enough to protect their rights across the board. So what we can sort of sum up from this first stage of the development of EU criminal justice cooperation, one that lasted since 2002, I would say that the year of the adoption of the framework decision on the European arrest warrant in 2015, which is an important date for the reasons I will say, is that on the one hand, the principle of mutual recognition and the duty to trust other member states that stems from this principle of mutual recognition leave very limited, if not any space, for the interests of the individual concerned. The individual concerned being obviously the person that forms the object that is subject to a request of surrender or any other requests adopted in the context of an investigation or a criminal proceedings that may affect his or her rights. So that is the summary of what can we gather from the analysis of the first part of the of this first stage of the development of EU criminal law. We can then move on and talk about what could be probably referred as a second stage in this development, which coincides to a great extent with the entry into force of the Lisbon Treaty, the establishment of a new legal basis to adopt the legislation regarding judicial cooperation in criminal matters, and a much more visible role played at a constitutional level, if you like, by fundamental rights. By constitutional level, we should here essentially mean the set of sources of EU primary legislation. And these sources include, of course, the treaties, and I would like to refer here, besides Article 2, which lays down the values on which the EU is built. I would also like to mention Article 6 of the treaty, which foresees, among other things, the accession of the EU to the ECHR, but perhaps more importantly, recognize the legal value of the EU Charter of Fundamental Rights as being the same of that of the treaties. So now the Charter is in and of itself part and component of EU primary law, and therefore as a constitutional and superior legal value if compared to EU secondary law. And also Article 6, as provided for by the previous version of the same article before the adoption of the Treaty of Lisbon also, but not less importantly, I would say, recognizes that fundamental rights recognized, protected by international convention and by the European Convention on Human Rights in particular, along with those that are covered by national constitutional traditions, should be regarded as general principle of EU law. So this new constitutional framework that came about with the entry into force of the Lisbon Treaty may have had an impact on the perception and the way in which other actors within the EU criminal justice arena have started to approach the topic of fundamental rights in relation to mutual recognition. The Commission in particular has shifted its position on the role of fundamental rights, especially in the context of the EAW. Unlike the earlier reports on the implementation of the framework decision, the Commission, ever since 2011, approximately, started to make clear that one provision in particular in the framework decision, Article 1, Paragraph 3, which is a very limited and generally framed provisions that only asserts that the interpretation of and the implementation of the European arrest warrants should not have the effect of exposing the requested person to a violation of fundamental rights. Well, that Commission said that this provision had to be interpreted in the sense, and in doing so, it went a different direction of previous reports in this respect. Well, the Commission said that, and again, here I'm quoting, Article 1, Paragraph 3, which is, as I said, this very broadly framed provision, does not mandate, so it does not require, not make it mandatory to surrender a person when the authority in the executing state is convinced, is satisfied that surrender, that the transfer of the person to the issuing member state would result in a breach of a requested person's fundamental rights. And this, the Commission said, especially in light of the numerous decisions adopted by the European Court on Human Rights regarding prison conditions in several member states of the European Union, which had in turn an indirect impact on the practice of the EAW, with several judges across the different member states starting to ask questions as to the possibility that surrenders in countries where prison conditions would be below standards, as defined by the Court of Strasbourg, would in fact entail a violation of EU law and a violation of the fundamental rights protected by EU law on the basis of the primary law and the primary sources of EU law that I mentioned a few seconds ago. Another important development that takes place after the Lisbon Treaty is the gradual inclusion in several instruments of mutual recognition. So instruments that are very much meant to do the same job as those that I talked about and were adopted in the 2000s, and most of all, the EAW. So this new wave, this new group of legal instruments, among which the European Investigation Order stands out as certainly the most important in practical terms, that were adopted in the post-Lisbon scenario, effectively try to incorporate within the text of the directives or the regulations clauses that allow for a refusal of the execution of a warrant if a risk exists that fundamental rights might be violated in the issuing state. I think it's important to highlight here that the very difference between these group of legal instruments that were adopted after Lisbon and the previously adopted ones is to do with the fact that in the framework decision on the EAW, but like in other framework decisions, including those on the transfer of financial penalties, the transfer of bail decisions or probation orders, and even the framework decision on the transfer of sentences, do not provide explicitly for ground for refusal. So there is no special and explicit provision for ground for refusal that would or that could be triggered in the case of a risk of violation. This new emphasis on fundamental rights would then also took on and developed and brought to a further level of intensity, I would say, by the case law of the Court of Justice of the European Union. It is important to mention at least two or three cases here. In general terms, like we could say that the landmark case here is the case Aranjuez and Calderaro, which concerned the risk of prison conditions in the executing state, exposing the requested person to a violation of their right to not to be subject to inhuman and degrading treatment recognized by the Charter, and other decisions that were in fact allowing for other types of derogations to the principle of mutual recognitions when, due to a lack of respect of some fundamental rights, and in particular to the lack of respect in the issuing state for the principle of judicial independence, acknowledged and paved the way for possibility to declare, for the possibility given to the executing authority to declare the arrest warrant invalid if some conditions are not fulfilled. This could be regarded as a new dawn for the protection of fundamental rights in the EU and EU judicial cooperation. Effectively, this consisted in adopting different types of derogation to the principle of mutual recognition, one being, as in the case of Aranjuez and Calderaro, with its very complex two-step test that some of your previous speakers might have mentioned, an additional ground for refusal that allows the executing judicial authority to abandon a cooperation after trying to obtain additional information from the issuing authority as regards the level and the quality of prison conditions in the executing member states. And as you probably know, this same test has been then applied to other types of fundamental rights, including the rights, and I would say now exclusively, and the right to a fair trial, and in particular its essence, meaning the right to an independent judge in the case of LM. So this new emphasis on fundamental rights has implied, of course, derogations to the principle of mutual recognition, and we don't see these happening, however, only in the context of the interpretation that the court has given to the framework decision on the EAW. There are other areas of EU secondary legislation in criminal matters that have been heavily subject to scrutiny on the level of protection of fundamental rights, one of them being the European Investigation Order, which probably features as the also most commonly used instrument of judicial cooperation across the member states, along with the framework decision on the EAW. And I would like to mention here in particular, because I'm speaking to several Bulgarian practitioners that might be in the room at the moment. The case Gavonodzov, if I'm pronouncing it correctly, and I would say even the saga of Gavonodzov, where the court first avoided to address the topic of the lack of appeals against a decision to issue a European investigation order to obtain investigative measures in the executing member states, and yes, and in particular the seizure of specific items and the possibility to hear a person as a witness. So very intrusive investigative measures that were not accompanied under Bulgarian legislation by a possibility of challenging them in court. And that was found to be at the end of a slightly long saga, I would say, incompatible with the principles established at Article 47 of the Charter of Fundamental Rights of the EU, and in particular the right to an effective judicial remedy. And that is an important development, I would say, because it shows how the penetration of concerns for fundamental rights protection does not regard exclusively the European arrest warrant. It has broader implications that go beyond the areas of cooperation that entail the privation of liberty, which is, of course, and by far the most intrusive context in which a decision can be adopted by another state and then enforced in a different member state, but also in cases where we are not talking about the privation of liberty per se, but where investigative measures may in fact have significant impact and entail a significant compression of some important fundamental rights other than the right to liberty. So this is something I wanted to mention. I would also maybe later in the discussion hear from you about how the situation has developed in Bulgaria as after the last decision in this case, which is from November 2021, if I'm not mistaken, and which effectively led to a halt of the EIOs issued by Bulgarian authorities, and whether some developments have taken place ever since within Bulgarian legislation. So to sum up the second stage of EU criminal law development that started in 2015, because the case of Aranios in Calderaru is a case from 2015, shows that while mutual trust and mutual recognition are increasingly framed as relative concepts, because the notion that there might be or there should be a duty of trust is gradually leaving the space, paving the way for a different understanding of mutual trust as a relative concept, one that should be earned in practice, among other things, by establishing a connection between issuing and executing authorities. I mentioned that in Aragnosi, the request, the refusal of the execution of a warrant can only take place after a request for additional information by the executing authority. So there is an element of relativity, but also an element of problem solving of the crisis, of a crisis of mutual trust through dialogue. And that leads effectively to a greater role being played by the individual in this context. So we notice shifting in the balance between the two poles of and the two parts of the spectrum that I have analyzed so far, the two poles of the spectrum that I've analyzed so far. Very briefly, before I come to the conclusion, because I'm afraid I might have already spoken too much, let me just turn to the role of fundamental rights that can be played, not just as a break or as a derogation or as an obstacle to mutual recognition or to judicial cooperation, and eventually to a form of approximation, but also as a driver, as a force that drives greater approximation, greater harmonization of criminal justice rules across the different member states, and in particular, defense rights or procedural rights, since the roadmap adopted by the Council in 2009 have been effectively the subject of a significant body of legislation that now forms part of EU secondary law in criminal matters. I would not go through all of the legal instruments that have been adopted throughout the years between 2010 and 2016. There are 6 of them addressing different aspects of the rights of the suspects and accused persons, and therefore, in general, the role of the defense. Because one of the starting points of the roadmap on procedural rights adopted by the Council was, in fact, that by the late 2000s, it became clear that a lot of progresses had been made on creating more effective judicial cooperation, but that had to do mostly with prosecution. And therefore, in order to offset or compensate these emphasis on prosecution, more had to be done to increase the protection of rights of the person that may be subject of criminal proceeding and criminal investigations, in order also to bring EU law in this area closer to the acquis, to the principles of the jurisprudence of the European Court of Strasbourg. This was possible also because of something that I mentioned in a previous slide. Therefore, the existence of a new legal basis in the treaties as amended by the Treaty of Lisbon, and namely the possibility under Article 82, paragraph 2b, for the Council and the European Parliament via the ordinary legislation to adopt directives, but also, as we then came to find out, regulations, but in first instance, I would say directives, to protect the rights of individuals in criminal proceedings. And what is probably the most significant aspect of this body of legislation is that the protection of rights of the person suspected or accused of crimes is meant to explicitly, because that's what the recitals to these instruments mention repeatedly, to improve mutual trust. So we are shifting, if you like, from a legislation, the one in the 2000s that very much marginalizes fundamental rights in the name of mutual trust, from a body of legislation that does essentially the opposite, that puts the protection of individuals, of their rights and liberties at the forefront to improve mutual trust. That is possible also because of a series of elements and features that these instruments have. In particular, the possibility of member states that have higher level of fundamental rights and procedural rights protection to maintain those levels of protection in some areas covered by harmonization. Consider, for instance, the right to access to a lawyer that is very effectively protected in some member states and traditionally less in others. So those member states that might have a higher standard of protection might be able to stick to that. Then there's an element related to direct effect that illustrates the significant impact that this legislation can have on national law, because it can be invoked directly by judges and courts in national criminal proceedings. And that was not the case with the so-called third pillar legislation adopted before the Treaty of Lisbon, and the previous legal basis that didn't give direct effect to those instruments. And to this day, the framework decision on the EAW does not have a direct effect, and that's something sometimes overlooked, but we should probably think about more often. And then finally, a more increased and a deeper scrutiny on the compliance by member states on the fundamental rights standards established by these directives, by means, among other things, of the infringement proceedings that the Commission can now bring forward against member states that are not complying with those instruments. With this in mind, and before concluding, I have to point out that the implementation of the EU rights directives, which of course has shifted the tone completely from the previous stages, the previous ages of EU judicial cooperation in criminal matters, suffers, however, of a series of shortcomings. The most important of which, I would say, and that I would only like to mention here, is the clear lack of effective judicial protection that some of the rights protected by the directive, that are enshrined in the directives, still suffer in domestic legislation. It is unclear, for instance, in some member states, how the right to interpretation or translation, when not effectively provided by investigating authorities, can be made effective through challenges or other appeals before independent judicial authorities, because that's what the Charter of Fundamental Rights requires. Well, this element in relation to the rights to interpretation and translation, but also in relation to other rights, for instance, the right to have a lawyer present during the police questioning, still suffer from a significant degree of ineffectiveness when it comes to their protection. And there are other elements of unsatisfactory aspects in the implementation of the EU rights directives that you will find here in the slide. And then the other element that is missing in the approximation regarding fundamental rights are the lack of common standards in areas related to detention, and in particular pre-trial detention, that have not been yet the subject of an autonomous legal instruments. The Commission has only come up with a green paper on detention in 2011, but has not as yet brought about legislation to harmonize sensitive aspects of pre-trial detention, including the time limits in which a person can be held in custody, the grounds for pre-trial detention that can differ significantly across different member states, and the possibility of a regular judicial review on the maintaining of a person in custody before trial, and sometimes even during trial. So to conclude, and I apologize if I spoke too much, and I used a bit more of the time that was allocated to me, is the reversible nature of the argument based on mutual trust and mutual recognition. As we saw in the first stage of the development of the history of criminal justice, this argument was very much used to belittle, to marginalize the role of individuals. Whilst in a second phase, and especially at the moment in which EU lawmakers have decided to legislate on fundamental rights, mutual trust and mutual recognition have become the rationale, essentially, to go forward with the harmonization, right? So there's been a shifting of gears, a reversal of the argument based on mutual trust that is very telling and tells us a lot probably about the underlying agenda on which this notion of mutual trust can be, depending on the circumstances, attached, and that requires further scrutiny, perhaps. Then solutions to the crisis of mutual trust have been proposed by the court, especially in its case law, by an increased use of judicial dialogue, but also in the legislation with the harmonization of procedural rights, as we saw. And still, blind spots remain in the current architecture of EU criminal justice and in the context of interstate cooperation in particular. And these are the lack of standards on detention and on pretrial detention in particular, a certain lack of effective judicial protection when it comes to some very important procedural rights that have been harmonized, and I would like to conclude on this, the lack of political will that is increasingly apparent in some member states when it comes to the implementation of procedural rights directives and other forms of instruments that regulate judicial cooperation, and that it's clearly at odds with the principle of loyal cooperation established in the treaties, and forces us to think beyond the pure realm of law and reflect increasingly in the years to come, especially in light of the rule of law crisis within the European Union, on the interactions between political environments, the political agendas of national lawmakers, and the respect of general principles of EU law, such as primacy, but also the principle of effective judicial protection and the respect of fundamental rights and other EU values. So I will leave it there. Once again, many thanks for the invitation, and sorry for not attending this very interesting event with you in person. Thank you so much.
Well, very warm thanks to Professor Martufi for his invaluable insights within our conference, and we very much appreciate for you taking time to take part. I think that your contribution really offered us a lot of food for thought, and with that, we do have some time for questions and comments, and I would like to open up the floor for any comments or questions that they are. I can see that Dr. Bianchi has already requested the floor. So Dr. Bianchi, you have the floor, please.
Thank you, Martufia. Very interesting speech. I would like to draw your attention to one of the results of the project, which is how this level of fundamental rights protection after Lisbon has also some effects on preventive measures, particularly the De Tommaso judgment concerning the quality of the law, foreseeability of the action, and so on. Because today, thanks to the technology, thanks to the evolution of the intelligence-led police approach, a lot of investigations or hybrid investigations are carried out in the preliminary stage, using also a number of European tools. And one of the questions we always have is, to which extent some of the tools like European investigative orders or other tools can be used in this context, considering the, let's say, philosophical doctrinal evolution of fundamental rights in this specific context. So I think that within the European architecture, another blind spot is represented by the relation between fundamental rights from one side and the preventive measure on the other side. So all these measures which have to do not with the privation of liberty, but the privation of movements or alternative measures taken during in the preventive or pre-investigative phase. My impression is that in this area, there is somehow a big lack. So we need to have a political and a technical effort to fill this gap.
Yes. Am I allowed to reply right away, or do we want to collect other questions?
I would suggest that we take questions one by one, and
So that
it will be easier. So please, you have the floor.
Yeah, then I will try to be very, very brief. I think it's a very topical question. Some of the considerations you developed made me think, in fact, of the recent legislation, proposed legislation on e-evidence and aspects that relate to pretrial measures that are also preemptive in their nature to a certain degree, and that have a potential to affect significantly fundamental rights, including the right to property, but also the right to private life. So there is an element of tension in that respect that needs to be considered very carefully. Then it is true that the case law of the European Court of Human Rights tells us something very important. It sets standards that apply to preemptive measures and to what I would refer to as kind of in general, like very preemptive and situational kind of instruments, like the restriction on the freedom of movement that you said a minute ago, which is certainly lacking from the point of view of EU harmonization, in the sense that we don't have framework decisions nor directives that regulate a mutual recognition of those judicial decisions when they are judicial decisions. Not all of them are judicial decisions. So we don't have a specific instrument on that, but we have elements of interference, if you like, between those preemptive measures that restrict the freedom of movement and other rights on grounds of mostly, I would say, dangerousness. So they precede a final conviction. Sometimes they are also coming at the very early stage of the investigation. I guess there are some interesting considerations that we can make between the application of framework decisions, such as the one on the European Supervision Order, that might be applicable to some of those instruments. We still don't have much case law interpreting that framework decision, but some authors have argued that preemptive instruments can, in fact, fall within the scope of the framework decision on the ESO. Another important, I think, considerations in this respect is whether the framework decision on the transfer of probation measures can be used somehow in that respect. And in both cases, whether we agree or not that these framework decisions apply to preemptive measures adopted in a very early stage of the criminal proceedings, the question remains, are these framework decisions able to increase the level of fundamental rights protection? And if so, how? Because they don't provide for a special ground for refusal on the basis of fundamental rights compliance. So we don't know if these kind of mutual review that member states are now allowed to carry out with the respect for fundamental rights, because that's essentially what Aragnosi and then LM have inaugurated as a new phases of essentially distributed and mutual review of fundamental rights respect, where the executing authority is kind of inquiring, if you like, into the compliance of fundamental rights within the issuing country. So that is no longer a kind of a top-down exercise as it was meant to be originally by the treaties, but it's now a more horizontal exercise that takes place between authorities in the two member states. So we don't know, because this legislation is still very much, because of the legal basis on which it was adopted, pre-Lisbon legislation, is still very much, I would say, not particularly sensible to the protection of fundamental rights. So that's something we really, and one question I would also raise in this context, which is perhaps less related to the outcomes of your project, but I think one that deserves attention in general, is how, to what extent the double step test that the court has developed in Aranhos and in other cases like this applies to other mutual recognition instruments, even those that have been adopted after Lisbon. That is not clear to me. The court has not been called upon to rule on this, but I think that will require further scrutiny in the future.
Thank you so much. And with that, I would like to ask if there are any other questions or comments for our speaker. Also, within the virtual conference room, if people who are joining us on Zoom, if they would like to take the microphone, please raise your hand, or just type your questions into the chat function. Right. I don't think that we have any more questions from the room. I think that everyone is desperate for a coffee. And there is no good time to stand between coffee and people. With that, I really would like to thank Dr. Martufi for his contribution and for being with us this afternoon. Since there are no further questions, I would like to invite you all for a coffee break, and coffee would be served just outside the room. And after that, we'll just have our final concluding session for today. So thanks, and let's go and